Now, I also wanted to introduce briefly Fair Trials for those of you who didn't previously know us. So Fair Trials is an international human rights NGO that campaigns for fair and equal criminal justice systems, exposing threats to justice and identifying practical changes to try to fix them. We support movements for reform across different regions, including in Europe, and work in partnership with lawyers, with activists, academics, and other NGOs. And thanks to this network, we can offer a comparative expertise, a comparative perspective on how to tackle failings within the criminal justice systems globally. Now, as part of our work, we've been researching the impact of the different uses of artificial intelligence in criminal justice in Europe, and very much welcome the EU's initiative to create a legal framework to regulate its growing uses before they become even more widespread and even more entrenched in practices. So this creates a unique opportunity right now, an opportunity to pause, to challenge perceptions that technology is efficient, that technology is neutral, and for us to critically assess these systems to identify the risks of harm that they present, the harm to fundamental rights, to fairness in criminal proceedings, and also risks to the justice system itself, which we need to do if we want to ensure that the legal framework that is being created is robust enough to address these risks. So today we will be discussing and hearing from experts on artificial intelligence in policing and criminal justice, including people impacted by these systems, by a member of the European Parliament, leading lawyer organization, and civil society experts. Now, as you may have seen, we published today our report named Automating Injustice, and we will first hear a presentation of our research and analysis from the report's author, my colleague Griff Ferris, a legal and policy officer at Fair Trials, who leads our work on AI and technology in criminal justice. Griff, the floor is yours.
Hi, everyone. Thanks, Laura. Thanks for joining us today, everyone. So I'm going to give a summary of our report, Automating Injustice, which you should have all received and which is now published. So with many areas of our lives, technological advancements are changing how law enforcement and criminal justice authorities operate. And these authorities are increasingly using the vast amounts of data that they hold about people who come into contact with the criminal justice system, such as crime reports, stop and search data, and arrests data, as well as other information held by public authorities and private companies. And that includes information from health services, welfare and benefits authorities, financial and credit information, and more. And this is being used to assist with strategic and individual decision-making using artificial intelligence and automated decision-making systems. This trend is often driven by financial pressure, pressures for greater efficiency, and misguided perceptions about the efficiency, reliability, and impartiality of these technological solutions. As a result, those systems are increasingly being used in Europe and in criminal justice systems across Europe to profile people, predict their future supposed behavior, and assess their alleged risk of criminality or reoffending in the future. Those predictions, profiles, and risk assessments can influence, inform, or result in policing and criminal justice outcomes, including surveillance, stop and search, fines, questioning, arrest, detention, prosecution, sentencing, and probation. They can also lead to non-criminal justice punishments, such as the denial of welfare and other essential services, and even the removal of children from their families. Our report, Automating Injustice, examines this, examines these systems, how they're created and operated, and their impact on people and their fundamental rights. It's the product of extensive open source research and investigation, freedom of information requests, reviewing published research, and interviews with impacted people, lawyers, and practitioners and experts in the field. And what we found and what we have published is that predictive profiling risk assessment systems currently being used within criminal justice in Europe are further fueling and legitimizing racial and ethnic profiling and discrimination. They're normalizing preemptive law enforcement and criminal justice action, leading to the infringement of fundamental rights, including the right to a fair trial, the right to liberty, the right to a private and family life, and data protection rights. These systems, introduced with little or no safeguards, no consideration of their impact on the individuals and groups targeted and subject to them, and with negligible consideration for human rights and the wider societal impact, are effectively automating injustice. Just a very quick note on definitions, because there are differences of opinion as to the definition of artificial intelligence and its true meaning against how it's widely used in practice, and there is no widely accepted definition. Indeed, the term has been used to encapsulate the most basic of computer-based analytical systems. Automated decision-making is another broader term that encapsulates all systems which process data and other inputs and produce outputs which influence or assist with human decisions to different degrees. And so that's why we're using the terminology that we are. So to give a summary of the main points made in our report, they are as follows. In terms of discrimination, AI and automated systems reproduce and reinforce discrimination on grounds, including but not limited to race, socio-economic status, and nationality. These systems are created and trained and operated using data. That system analyzes that data, and from that analysis, it produces an outcome or a decision. But the policing, law enforcement, and criminal justice data and records used to create, train, and operate these systems do not represent an accurate record of criminality or criminal behavior, but merely a record of law enforcement, prosecutorial, or judicial decisions and actions, the crimes, locations, and groups that are policed, prosecuted, and criminalized within society, rather than the actual occurrence of crime. That data, that criminal justice data, is reflective of systemic, institutional, and societal biases, which result in Black people, Roma, and other minoritized ethnic people being over-policed and disproportionately detained and imprisoned across Europe. Those biases are so fundamental and ingrained in that data and the information that is used in these systems that it is questionable whether any such system built in this way would not produce such outcomes. In terms of the right to a fair trial and the presumption of innocence, these predictive profiling and risk assessment systems, they target individuals and profile them as criminals, resulting in serious criminal justice and civil outcomes and punishments. And this occurs before these people have actually carried out the alleged action for which they're being profiled. In essence, the very purpose of these systems undermines the fundamental right to be presumed innocent. In terms of transparency and accountability, these systems often have technological barriers that prevent effective and meaningful scrutiny, transparency, and accountability. For example, many people subject to AI and automated decisions, predictions, or profiles will not even know about it. And if you don't know about it, it makes it very difficult, impossible to challenge that decision and the outcome. There are also serious concerns around the lack of meaningful human input into these automated decision-making systems, as well as their direct use and impact on children and young people. We will hear more about the first-hand impact of the outcomes of these systems in the Netherlands from Diana Sarjo next, but here is an outline of some of the systems and examples of some of the systems used. And of course, full details and analysis is in our report. So in Amsterdam, the Amsterdam municipality started the Top 600, an automated risk modeling and profiling system in 2012, in partnership with police and social services. It attempts to profile the top 600 young people over the age of 16 who it considers are at most risk of committing crime in future. The criteria used by the top 600 to assess the risk of someone committing crime is chosen by the police, the public prosecution service, and the local authority. And this criteria includes whether someone has been arrested as a suspect for certain crimes, whether they have been a suspect in a crime within the last 2 years, and as well as other criteria, including whether they have presented to a bankruptcy judge. The use of this arrest and suspicion data and reports, police reports, as well as information about people's financial situation as part of a risk model which has criminal justice implications is obviously extremely concerning. The Dutch Public Prosecution Service described the outcomes of the Top 600 system as punishments and interventions. It states the intention is to punish quickly, severely, and consistently through a combination of punishment and care. The prosecutorial service has stated that they will seek higher and more severe penalties for those profiled by the Top 600, as well as ensuring active and rapid prosecution of minor offences. And Dutch lawyers have alleged that prosecutors also seek the longest possible pre-trial detention for those listed on the Top 600. The consequences of a risk profile by this automated system, therefore, shows a very dangerous blurring of the boundaries between care and punishment. And the discriminatory outcome of this system is clear, as more than 1/3 of those profiled are of Moroccan descent. Another very similar system, also in our report, called the Top 400, which is targeted at under 16-year-olds, profiles them on the basis of whether they have been arrested as a suspect for certain crimes, whether they're associated with alleged gang activity, also based on police reports, police intelligence, as well as criteria about whether they've been absent from school or changed schools regularly, or even whether they've been subjected to police surveillance. In a separate example, used to decide whether people should be prosecuted in England and Wales, a police force in England developed its own machine learning algorithm, which profiles suspects to predict their risk of reoffending in the future, giving them a risk score. That AI-generated risk score is used to advise whether to charge a suspect or release them onto a rehabilitation program. If individuals who have been assessed as moderate risk successfully complete that rehabilitation program, they will not be prosecuted and receive a criminal conviction. The outcomes generated by that system therefore have very significant consequences for that individual's criminal justice outcomes. And the principle of using that kind of historic data about an individual to make predictions about their future behavior very much brings into question the presumption of innocence. The data which is used in that system includes criminal justice data, crime reports, arrest data, as well as non-criminal justice data, such as financial credit data, which profiles people based on protected characteristics, socio-economic status, as well as proxy information for protected characteristics, resulting in discriminatory data profiles. So in summary, what we're calling for in this report is for a prohibition on the use of these systems, because no number of safeguards short of a full statutory prohibition will protect against the fundamental harms that I've summarized and which are outlined in much more detail in our report. And we would like to see a ban on the use of AI and automated decision-making systems by law enforcement and criminal justice authorities used to predict, profile, and assess people's risk or likelihood of future criminality. In addition, there must also be very strict safeguards around other types of automated systems used, including mandatory independent bias testing, a requirement for strict transparency, and the prevention of legal protections such as trade secrecy or intellectual property requirements. Outputs from these systems must be able to be understood or scrutinized by their controllers, as well as the subjective decisions such as suspects and accused persons, as well as the general public. And individuals must be notified whenever there has been an automated decision taken about them, whether that's assistive or influential, that's impacted a criminal justice decision. And there must also be clear routes for challenge or redress for individuals attempting to contest or challenge these decisions made by automated systems. So for more detail on anything I've said and for these systems and examples, please have a read of our report, Automating Injustice. Thanks very much.
Thank you very much, Griff, for such a comprehensive overview of the different systems already in place in Europe and the risks that they present, that really show that however remote or abstract this may feel, these systems already have very real effects on prosecutions, on incarceration, and deeply affect the lives of many people. And to tell us more, we're delighted that Diana could join us today. So Diana is the founder of the association called The Mother is a Key, an organization that Diana set up to help the parents and children impacted by these profiling systems that Griff described, used by the Amsterdam police and other authorities. So, so Diana will share with us her experience and her work. So I'll hand over to you, Diana. Thank you.
Thank you. Forgive my English if I have to look for words sometimes. Well, thank you for having me. What Griff Ferris told about the 600, and all the boys were 16 or older. My son was 14. And the youngest kid I know that was on the 400 was 7 years old. So that's why I started to think about, whoa. But my question was, how did my boy get on the list? because when I start researching and I start reading reports about the 600, it's very little information for parents to find. But I was wondering how he did a crime, he committed a crime. But if I read the criteria for the 600, he shouldn't be on that list. So that was so crazy. But the way they treated him, hunted him, because you need police contact to get in the top 400 or 600. And that's very easy for boys like that, because when he was 11, he was already target, you know, show your ID, things like that. But that also counted as a police contact. And I was thinking, did he stand a chance? And I'm a single mother, so I fit the profile, because I was reading all those reports. But one thing I couldn't get out of my mind, how was it possible there were so many Moroccan boys, Caribbean boys, and just a small amount of white boys? And then I started doing my own research, but people are afraid to talk. So I asked the street coaches, why do you need to target these boys? And they said, we get a list. So where does that list come from? Because the boy didn't commit a crime, maybe they stand in groups or having fun. And if you go to different areas of Amsterdam, you will see a representation of the area. But where I live is mostly white, well-educated people. And I asked the boys, how does the list look? And it was mostly Moroccan boys, not one white boy. And I could tell, I could pinpoint through my work but that boy should be on that list too. But they never make it to the list, because I have mothers and we're all kinds of ethnicity and who have the same problems as my boys, but they're not on the list. They're not in some kind of other list. And I was thinking, something ain't right. And then somebody told me about artificial intelligence. I said, how do they get to the data? And it was, of course, because when your baby is born, you go to consultation bureau. That's the first thing, how they get the data. And they start following your kid, because they always ask on school list, where do you come from? Where are your parents born? We don't fill it in anymore. We don't tell anybody anymore where we come from, because they use that data from starting to tell that's how your kid will end up. My daughter was very intelligent. They tried to push her down to a lower education. I said, it's everywhere, because they're taking tests. She scores very high and still she couldn't make it. They told her it's her behavior. I said, what kind of behavior? And everywhere where you see it, they use data, because even when I start reading my own reports afterwards, I can change it, because it will stay the same. They tell me you can't change it, but they use that data that's false, profiling, because if you're a single mother, you need to fit in some kind of, how do you say, room box. And if you're out of the box, they will push you in it. They will strip you down. I lost my money because my son was in the 600. I lost my job. So I started to fit in the box. I didn't even know it, but you get pushed into it. So everything will make it right. So now I fought back, started my own foundation, and I wanted to talk to more mothers. I was the first one who came out and told, this is what it did to me. And the response was big. And mothers started writing me, we're having the same thing. And what was so similar, single mothers or even white mothers, but their son is mixed, all this kind of type of boys. And I was like, how is it possible? And everything, well-educated mothers, but if they're single and the child has been on school, everything, everywhere, intelligent boys. And then everything was right. But when they started to get 11, then the trouble starts. So I started researching and we asked about what do they use to target our boys? And they're very quiet about it. And then a lot of people start talking to me, journalists, Diana, you should look into artificial intelligence. I was like, what the hell I need to do with that? But then I started researching and I met Griff and I read that, like, oh my God, it's true. I recognized everything, but you cannot put the dots together. And you think, how do they get to those boys? Because when you walk around, you know, those people who are there to help you, they walk around the area and they start pointing at children and said, that one will be on the list, that one will be. I said, how do you know? And it's scary. And when I read my own report about the police, because the police now, if your child gets in contact with the police, they make, we call it zorgmelding, a notification to the care system. And it wasn't right. Even in one, how did I get them? They told me I had cats. I never had cats. They told they got in my house and they take the smell of cats, things like that. And they saw 2 cats. I was like, huh? I felt like Alice in Wonderland because I was still looking for the damn cat. I thought maybe the neighbor's cat, but that's what they put in everything that will downsize you. And it's terrible because I'm an intelligent woman and I know a lot. I come from the bank world. But they make sure that you get into the welfare system because they tell you you're not allowed to work. You're not allowed to talk to people about certain things. And if you say something isn't right, they say, no, 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 no. You cannot talk to that because otherwise we will take your child away. So you keep quiet. And a lot of mothers keep quiet because they're losing their children and they start talking about the system. And that's scary. And I saw somebody ask a question about facial recognition. You know, they want to use that now, but that's going to be a big problem because my sons have iPhone and they use facial recognition, but they can open the iPhone with their own faces because they have similar bone structures. So artificial intelligence, who's going to control that? Who's going to keep us safe? And that's the scary part, you know. I'm all in for progress and numbers and that kind of things, but the use of it, who's going to control that? Because if I now see how many boys of us are targeted now, and they get in all kind of lists, and every time and it's not only in other cities they call it the top X, the other city they call it all different, but the same thing, the same boys. And it all starts when there are 11, they get on a list. The boy, my other son, was on the 400 and he cried. He said, why am I on the list, Mama? I didn't do nothing. And they didn't want to take him off. And after that, he started behaving like a 400 kid. And he's still damaged. There's nothing I can do about it. So now my mission is to save other children. Sorry if I get emotional, but I see what happened to our boys. You know, other people are sitting behind the desk, but I see it every day. The boys are feeling useless, like they have no way out. And I'm trying to give them a way out. And the boy who started it is now a man, the top 600. And the craziest thing, he came out of the prison after 10 years. He went in as a baby, came out as a man. And you know that the boy called me from prison. He said, Ma'am, saw you on TV. Can we talk? I said, and he said, don't be scared. But I'm the man who started the 600 because of me and my friends. The 600 started, and it's crazy. And you see, they break them. The whole system breaks them. And they can't get jobs. They can't get to school. They're isolated. They're stripped down from every humanity. You can't get it back. You know, and all those boys who are in the 600 are in prison for worse. Some of them are dead. And one boy I know, they broke him really, and he's now in prison again. He's never the same. So I hope things will change, but I'm still fighting every day. And I hope someday that everything will be okay and I can quit. But that's my dream. I just want to give them fair chances, fair trials, because I see it also in the justice system. The difference between the boys, you know, if a boy comes from a good family, our mayor, her son, yeah, was was he was catch with a gun and things like that, a whole news thing, and he got bureau halt. And we had a similar boy who did the same thing like the mayor's son, and he got under 600. Same thing, never had problem with police, nothing. And he came in the same situation, had fun with his friends, made a mistake. He ended up in the 600. So there is a difference. No fair trials, nothing. It does matter where you're born. It does matter where you're from. And we can all say it's not like that, but it's the truth. We feel it. I see the mothers here broken and we fight back. They're not scared anymore. I gave them a voice, they start talking and they're not afraid to talk anymore. Because if I can save anybody's child, I will. I will. I hope you could understand me because my English is needs also start up sometimes. But I hope there are people who are willing to fight with us, for us, and for those children. Because they deserve a chance, and they're good children, and they're intelligent, and they deserve every right for a good life. So yeah, you want to know more?
Well, thank you so much, Diana, for sharing your experience, sharing your emotions and your feelings about this dramatic situation. It's just remarkable to hear about your battle against such an opaque and, as you describe, such a scary system that's destroying lives, destroying the youngest of lives. It's just very, very upsetting to hear, and it's beautiful to hear that out of this you've created solidarity across other families, other mothers, and that you're working to try to prevent this happening over and over again, and evidencing the targeting of minoritized ethnic people and the inequality in rights and fairness. So I think you raised two very interesting questions as well that I think we can now put to the next speaker on the question of control.
I wanted to say, add one more thing. They're starting a big master plan here in Amsterdam, and the people they're targeting in criminality, in criminal things, are the single mothers again.
Yes.
So that's starting. So after this, I'm going there to defend them again from this is not okay.
Absolutely. And there is this question of control, I think, and you also asked who can keep us safe. And I think these are absolutely fundamental questions that now must be on the table for the EU, who is looking to regulate the use of these different systems, and what we can do to prevent such harm from happening ever again. And so just by way of transition, so the European Commission has published a proposal for binding legislation, the Artificial Intelligence Act, in April 2020, in April this year, sorry, to regulate the uses of AI. And now the European Parliament, well, the European Parliament has long been active as well on the matter, adopting a series of resolutions and reports, setting up a special committee on artificial intelligence, and it's very high on the Parliament's agenda. So I'd now like to hand over, and then we can go back by all means, Diana, to more points you'd like to make.
No, it's okay. Just tell them I still got 10 good years to fight, maybe.
Good, we'll make sure to participate. To hand over to Peter Vitanov, a member of the European Parliament, who is, amongst many other positions, a member of the group of the Progressive Alliance of Socialists and Democrats in the European Parliament, and head of the delegation of the Bulgarian Socialists in the European Parliament. MEP Vitanov is also rapporteur of the Civil Liberties and Justice Committee of the European Parliament, so the LIBE Committee, which produced a report called Artificial Intelligence in Criminal Law and its Uses by the Police and Judicial Authorities in Criminal Matters. Now, this report is due to be debated by the European Parliament very soon, and I think that experiences such as yours, Diana, are absolutely key in this discussion. So May I hand over to you to talk about the report, MEP Vitanov, and the role of the European Parliament. Thank you.
Thank you. Thank you for giving me the floor. I hope you can hear me well, because I'm not in the office now. But honestly, thanks for having me here. It's an honor to be here. On one hand, to look, maybe Diana should come to the European institution, because her presence there will be way more useful than some of my colleagues there, because she basically touched the disadvantages of this system. And it is really hard in the European Parliament because there are so many different interests. When we talk about business interests, about lobbyists, the human rights perspective is always not at all vocal compared to the business perspective. And then when we talk about artificial intelligence in criminal law enforcement, there is always a business element there. That's why there are certain political groups that are really keen on implementing this system without any caution when it comes to fundamental and human rights. And it's been a constant fight. Yes, you are right. I'm a rapporteur on the artificial intelligence in criminal law and its use in the police and judicial authorities in criminal matters. But it is really hard to find a thin balance between the technological progress and keeping the fundamental and human rights. And I would say, but of course I'm a socialist, and it's easy to say, we always look from the human rights perspective, from the people's perspective. But there are certain political groups, those that are identify themselves as right, where always the business has a leading role. So it was really hard to find a team balance, because we warned some of our colleagues about the problems that these systems, the artificial intelligence in this matter can bring. And the good thing is that we basically managed to underline some of the problems. And I will quote some of the points in this report. We noted that the predictive policing, especially predictive policing, is something that is really concerning and bothers us. Is among the AI applications used in the area of law enforcement, but it cannot make reliable predictions on the individual behavior, and therefore cannot constitute the sole basis for an intervention. We point out that several cities in the United States, because there was a Libe mission right before the COVID pandemic erupted. The Libe mission that was actually influenced a lot to the outcome of this report. So this Libe mission, that several cities in the United States have ended their use of predictive policing system after audits, recalls that during the Libe Committee's mission to the United States in February 2020, members were informed by the police departments of New York City and Cambridge, Massachusetts, that they had phased out their predictive policing programs due to a lack of effectiveness, discriminatory impact, and practical failure. Absolutely the points that Diana and not only her mentioned. And we also called for a permanent prohibition of the use of automated analysis and or recognition in publicly accessible spaces of other human features such as fingerprints, DNA, voice, and other biometric and behavioral signals, because this is absolutely wrong and it is discriminatory. And we also called for moratorium. We couldn't fight for a total prohibition, because I opened the bracket. My personal opinion, I definitely agree with your position. And it's not a question whether an AI has a potential to result in racially biased outcomes. We actually know for sure that this is the case, and your report is a perfect example of it. But let's be honest, it is very, very hard to win that battle. So we called for a moratorium on the deployment of facial recognition system for law enforcement purposes that have the function of identification, unless strictly used for the purpose of identification of victims of crimes, until the technical standards can be considered fully fundamental right compliant. So we believe that we still don't have enough evidence that the fundamental right of people will be will be kept, and that is why we have a lot of concerns when we talk about using AI in the law enforcement. And we actually 2 or 3 days ago we had the opportunity also to meet the Vice President of the Commission, Margaret Vestager, because she was presenting the Artificial Intelligence Acts, and I will say that our report, we intended with our own initial report to draw these red lines that the Commission should follow. Unfortunately, due to some not only technological but also political reasons, we were not able to vote that report in plenary, when we will do it in October. But we wanted to set some of these red lines that the Commission would never cross. So, and in our conversation with Madam Vestager, I confess that definitely the European Union needs to catch up with the technical developments. The use of AI has been growing exponentially in all of the spheres, but we as co-legislators, we have to do our best in order to safeguard the fundamental rights of all of the European citizens. And I can truly say, yes, I might not be black, but you know that Europe, we have different speeds, and my country represents the last speed. I'm Bulgarian, and a lot of Roma from Bulgarian origins and a lot of other Bulgarians have been subject of discriminatory due to this artificial intelligence in law enforcement. So maybe as a conclusion, technical progress should never come at the expense of the fundamental rights. And also I believe that when we finally have a regulatory framework, every person who feel that might be a victim of this artificial intelligence in this sphere must have the right to challenge these decisions, including with retroactive aspects, and why not compensations as well. Thank you so much, and I'm really, I must say that I'm amazed by your report, and I'll be listening very carefully to the end. And I really hope that this discussion can reach to some of my colleagues in the European Parliament who can only see artificial intelligence only through the business perspective. Thank you so much.
Thank you so much for sharing these insights into the political process, and thank you as well for keeping that very strong stance on fundamental rights and pushing back on business and financial and commercial priorities when in the face of this overwhelming evidence experience, such as Diana's and her sons, and the failure as well of these systems in the US that you also noted. Thank you very much. I just wanted to thank just the participants as well who've been sending in, the attendees sending in questions, which we will turn to at the end. And please do continue to send questions through the Q&A function. I'd now like to hand over to our next speaker and hear about the perspectives of lawyers representing people affected by these systems. Diana had flagged this lack of information, of not knowing where to start, and where this is a fundamental point as well. So James McGill, who was due to participate today, was unfortunately not able to make it, but we're very lucky to have Martin here with us, a colleague of his from the Council of Bars and Law Societies of Europe, who stepped in. So Martin Sacleux is legal advisor in charge of the IT Law Committee, the Surveillance Committee, and the Future of the Legal Profession Committee at the CCBE. So Martin, over to you. Thank you.
Thank you very much, Laure. So first, well, thank you for inviting the CCBE to this event, and thank you for this very important report. I think it will be very useful for the work of the Council of Bars and Law Societies of Europe. First, I want to present our apologies for the absence of our Vice President, James McGill, who had an urgent matter to deal with, so he cannot be present today. Just to briefly introduce the CCB, the Council of Bars and Law Societies of Europe, represent the bars and law societies of 45 countries, and for them, 1 million European lawyers. And we respond regularly on behalf of our members on policy issues which affect European citizens and lawyers. And within such issues, the digitalization of justice in the European Union, and of course, the use of artificial intelligence in our justice systems. And so at the CCB, we think that with the great benefits offered by technology also comes a great responsibility to ensure that the use of such technologies in justice remains ethical, fair, and human-centered. And we saw with the example and the testimony of Diana that the use of such technology can be very harmful in the life of the people and in the life of the citizens. So for us, it is of paramount importance that such considerations are taken into account in the development, the creation, and the use of artificial intelligence tools in our judicial systems. And we think that much debate is still needed to critically assess what role, if any, actually, because we can go back. Well, I think it won't be possible eventually, but what role, if any, AI tools should play, especially in our criminal justice systems? And I want to remind that change in this aspect should be embraced where it improves, or at least where it does not worsen the quality of our justice systems. And just so to go into the subject, regarding criminal justice systems, AI raises several challenges for lawyers, when it is used by police forces and law enforcement authorities for the prevention of crimes, for the collection, the analysis of evidence, and also when it is used by courts themselves. First, well, we saw that with a testimony, for instance, that AI deeply undermines fundamental rights, the right to a fair trial, the right to privacy, the right to life, equality, and non-discrimination. And just to speak quickly about the use of AI by police forces and law enforcement authorities, well, thank you for your report, because you are targeting specific tools such as predictive policing or reoffense risk management systems. Maybe, well, I won't go into the details, but maybe a few words, for example, on the use of facial recognition and technical surveillance measures, which are used to intercept, to collect and analyze data, which then will be used as evidence by the prosecution, for instance. So with such kind of systems, we observe serious flaws that endanger civil rights. It has been proven that such systems do not recognize people from different colors, for instance, and they are also leading to mass surveillance. For example, with national security authorities using trigger words on internet or on the surveillance of phone conversation. And when such kind of trigger words are not precise enough, it leads to mass surveillance of phone conversation, email correspondence of millions of people, and without a proper legal basis. And within this million of people, of course, you have lawyers and their clients. So we have here specific issues for lawyers. First, one of the issues is we don't have access to the proper evidence and the proper data, which is used as evidence. Why? Well, because simply we are not aware of the use of such kind of surveillance. And if you are not aware, you cannot access it, and then you cannot, and Griff explained it before, you cannot contest it and challenge it properly before the courts. And so it raised a problem regarding the right to a fair trial of equality of arms between the defense and the prosecution. Another issue is that there is no specific protection of professional secrecy and legal professional privilege, which are protecting the confidentiality of lawyers and client communications, which are based, on the proper administration of justice and the confidence of the people in our justice system. Basically, internet service providers and law enforcement authorities, they do not have the technical means to assess if the data which is collected is the data protected by professional secrecy. And this is what we recalled in our position paper regarding the new mandate of Europol. And I think that a lot of people, this specific legislative file on Europol deserve a lot of attention from all of organizations because there are also several risks for fundamental rights in it. And that's why the CCB was asking for the creation of such technical means to protect the professional secrecy, for instance. Beyond facial recognition, you have also mentioned reoffense risk management systems, which can be very, very dangerous, used to predict the probability of a person to commit future offenses. So we have the example of Diana, and I read into your report, but you mentioned also the case of the algorithm used by the police of the city of Durham, where you have basically three groups, a categorization of three groups of offenders based on the risk of reoffense in the next 2 years. So you have a categorization between low, moderate, and high risk. And the consequence is, if you are classified as moderate, you have access to rehabilitation program. If you are not, you are facing prosecution and then conviction. And so here you have a huge problem of discrimination because people in the same situation are treated differently based on an algorithm, the result of an algorithm, and which also can be biased, in its development, in its programmation, because it's of course programmed by humans. And I think that your report is targeting this specific issue. So you have this problem of discrimination, you have a problem of also the independence of justice and the impartiality of the judge, because of course, if it is introduced in our justice system, the judge will rely on such kind of evidence brought by this kind of AI tools, and it is going to be difficult for the judge to use other evidence. It is easy to rely on the machine. It is very easy because in the human mind, the machine is never wrong, So I think it poses a very problem for the independence of justice and the impartiality of the judge itself, because eventually the decision of the judge will rely on the results of an artificial intelligence tool, and which is based on the programations made by other human beings with their own thoughts and characteristics, And so then you also have the problems regarding the rights to fair trials and all inherent rights, equality of arms, presumption of innocence, the rights of the defense, because of course, the problem is for the defense lawyers, the methodology and the use and we are going to the results of the use of such tool is not communicated, and so there is no possibility to challenge it before the court. And so this is really problematic regarding the right to a fair trial. I'm going to continue with also issues regarding the use of AI by courts. Our justice systems are based also on the adversarial proceedings. It means that judges are relying on the elements brought by the parties, and the parties then have to be able to know all the elements which can influence the decision of a judge, and then they will need also to have the possibility to discuss it. But the use of AI and the post-pension use of AI create risk to unbalance the mechanisms. We need to have decisions made by the judge herself with following an adversarial process, a judge who is independent, impartial, and we need a decision which is explainable, and we need to understand the motivation behind the decision, the sentence. But with AI, we have a lot of problems here. We have no more debates. We have no more adversarial debate between the law, the defense lawyers, and the prosecution. It is also, we have conclusions which are brought not anymore by the judge, but the AI system itself. We have no more transparency because we don't know what is coming from the judge, what is coming from the AI systems. We have no more equality of arms because, as I explained before, it is difficult for the lawyer to contest the elements brought by the prosecution, and no lawyers need technical experts because by themselves they cannot do it. You have no more impartiality, no more explainability, so it raises numerous issues, and that's why the CCB has raised the need to uphold minimum safeguards and principles. The principle of identification, you need to have a possibility to identify the use of AI by law enforcement, by the courts. The principle of non-delegation, we think that we need a right to a human judge, you know, and not only a judge signing a decision made by an AI system. We need a principle of transparency, the possibility for the parties to verify the data input and the reasoning of the AI tool. Of course, the principle of discussion, where parties need to have a possibility to discuss and contest AI outcomes in an adversarial manner, and of course the question of neutrality and objectivity of AI tools. So this principle of neutrality is very important in our judicial systems, and that's why we are and I'm finishing, we are following the AI proposal, and we regret, you know, that it is not more targeted for justice and for its use by law enforcement authorities and by courts, for example. And so that's why, well, I cannot say too much about it right now because we don't have, the CCB has not adopted the position paper on it yet. But yeah, we have problems with the classification of high risk in the justice, which is not quite clear within the definition of judicial authorities, for instance, and the fact that the AI is considering as assisting the judge with no definition of what is assisting in the text. Thank you. I was a bit long, but we have a lot to say on this issue.
Yes, thank you very much, but a lot to say and a lot of really interesting, important issues that really show that there's a lot more thinking that's needed around this proposed legislative framework. So very interesting. Thank you very much, Martin, for highlighting the impact of these tools on the right to a fair trial, and also on the independence and impartiality as part of that of judges, which really raises the question of a rule of law framing as well around these issues. So thank you very much, Martin. And I'd now like to hand over to our last speaker before we turn to the questions from the audience. Thank you very much for your questions. We're honored to hear from Sarah Chandler, who is Senior Policy Advisor at the European Digital Rights Network, EDRI. Sarah leads EDRI's work on AI and non-discrimination with respect to digital rights, and she also has a lot of experience in racial and social justice. She previously worked in advocacy at the European Network Against Racism, ENAR, and is also co-founder of Equinox, the Initiative for Racial Justice. Sarah, thank you very much. The floor is yours.
Yes, thank you so much. And can I just say it's such an honor to join such an important event with such powerful interventions, and also, as you've all mentioned, at such an important time. I'm very I guess, hopeful by all of the resistance that I see mounting, but also the increased political awareness to some of the dangers of AI in the criminal justice sphere. And I was very impressed by the report. As you've said, I'm Sarah, Senior Policy Advisor at European Digital Rights. If you don't know about EDRI, it's a network of 45 organizations working to defend and advance rights in the digital sphere. We have done a series of work around AI, and what we have really tried to make the focus of our AI work is that any attempt to regulate it is human rights based, that is centered in social justice, but also that we don't presume that AI will be inherently beneficial. And actually, I think this is such an important topic when we talk about AI in the criminal justice sphere, is that in the face of overwhelming evidence of the harms and the dangers and how in some cases AI systems can ruin people's lives, we really need to draw red lines on the uses of certain AI systems. And in criminal justice is one of those key areas. Today, I just want to really briefly make a few reflections on the report and things that I was thinking of when I read through the report, and then end with 4 recommendations, particularly for politicians, legislators who are actually taking very important decisions as we speak to influence the EU's AI legislation. So first, on to the reflections. One thing that really struck me about this report is that we see the increasing expansion through AI systems or predictive policing systems, expansion of the criminal justice sphere. And Griff already mentioned that. We see that we are criminalizing acts, criminalizing things that were previously considered outside the criminal justice sphere, and yet we're expanding the scope. What is, or essence, expanding the scope of policing without a legitimate public debate as to why we are doing that, using the technical arguments of algorithms as AI as a way to push in political conversations and expanding political powers of law enforcement and police into what were previously social areas. What we see with policing, predictive policing systems and other AI tools in the criminal justice sphere is that we are in essence using AI to criminalize people, not necessarily for what we've done, but for who we are, where we live. And that was rightly pointed out in the report, the impact on the presumption of innocence. The second, and I think this is one really close to my heart, we've seen now, and everyone I think on the panel has said this, AI systems in this sphere are embedding discrimination, existing historic patterns of structural discrimination, and particular emphasizing what already exists of this racialized link between how someone looks, where they live, and criminality. I always really like the work of Patrick Williams, who's done some really important work on the link between risk, the concept of risk in AI, and racialization. And I see that Becky Hodge and also another person, Rebecca Delso, Becky is in the audience today, and she's really commissioned some of the initial work into this link between racialized policing and data. And if anyone is interested, there's a really good report called Hardwiring Discrimination, Data-Driven Policing, which was funded by the Open Society Justice Initiative. So this is something, another great report which already highlights what we know. The link, AI is increasing the link between racialized criminalization processes, and we need to stop that. We see therefore that the systems that we're talking about, they're really based on patterns of policing, not based on patterns of crime. And we need to remember that. If they are based on patterns of policing, what we're seeing then is that if we see this moment of reflection about policing through Black Lives Matter, but also that we are in this stagnating crisis of racial inequality, we need to really be careful about any system that sort of reiterates racialized policing. But also class. We see many of these systems are fundamentally targeting people who are poor or working class and codifying a presumed link with certain social behavior, also an economic behavior and crime. So as Diana already said, Single mothers are being targeted. We're seeing people with low school attendance are targeting, and also crucially, predictive policing systems are emphasizing this link between crime and certain areas, location. We all know where you live hugely determines how much police attention you are subject to. And this is something that has not been addressed yet, the location-based impact of AI systems. Another reflection I've been thinking about a lot is that actually these systems, because they are so difficult to challenge, we call them criminal justice tools, but actually they're creating further distance from justice. So they are harder to challenge, and many of the other reasons that Martin has given show us that actually these systems maybe shouldn't be called criminal justice tools, but actually are making this gap between people that need justice and also potentially people that are harmed from such system even wider. We at EDRI have really long pointed out that sort of any attempt to regulate AI must make sure that the people who are affected by these systems shouldn't be the ones that have to challenge them, because often they're in the least position to do so. And any system, any regulatory system that wants to challenge that needs to prioritize this notion of the burden of proof when it comes to AI systems. And then the last reflection that has been touched on, but really I think needs a lot of more exploration, is the role of the private sector in AI, particularly when we're deploying AI systems in public areas like policing, healthcare, migration control. What we're in essence doing is giving private companies more and more control over decisions that should remain in the public sphere and should be subject to democratic oversight. The same is the case for AI and policing, right? Many such systems, not all of them, but many such systems are developed by private companies. And the current AI law really keeps that responsibility in the hands of those same private companies to provide the solutions to the problems. We think this is a complete mistake, and we really need to explore how the link between the privatization of the public sphere and the introduction of AI into areas like policing. Into the area of my recommendation, so I will put into the chat a little bit later. EDRI has put forward some recommendations of what we think needs to see happen, particularly in the EU's AI Act. The first one is that you need to strengthen the prohibitions, you need to set these red lines, and also for AI in the criminal justice sphere, particularly in areas like predictive policing, we do need to see a full-out ban. Whilst the wording needs some work, I think we really echo the recommendation in the report that we need to see a ban on AI in the field of law enforcement or criminal justice system, in particularly those systems that purport to predict future behavior, including analyzing the risks of reoffending or offending, or predicting likelihood that certain individuals or groups will commit crime in the future, whether it be on the basis of certain personality traits, social behavior, individual or group characteristics, or crucially their location. That should be banned, and for the reasons I won't repeat because everybody has already said that is an absolute priority that needs to be seen and changed in this AI Act. We've consistently opposed the sort of notion that technical solutions can solve what are essentially political problems. And therefore the requirements that are put out in the Act, things like data quality, whilst we think that they might be positive in some cases, in cases like predictive policing, they will fundamentally not be enough to mitigate the structural harms that come with introducing AI into sensitive contexts like the criminal justice or migration sphere. In the Act, many of these use cases are categorized as high risk, but as I said, private companies are responsible for self-assessing how dangerous these systems can be, and that cannot be the way that this Act should go. Which brings me to I would like to mention a few other prohibitions that we would like to see. Many of you in the chat have mentioned facial recognition and other forms of surveillance. EDRI is also pushing for a complete prohibition on the use of remote biometric identification in public spaces. Facial recognition, as you note, and you have all noted that it's racist, discriminatory, and it's inherently in contradiction with the need for privacy as we access the public space. And we think that this should also be banned fully in the Act, not in the limited way that we currently see it. Same goes for many harmful uses of AI in the migration sphere, but also a number of invasive practices like biometric categorization, the idea that we can use human features to put them into categories, even on the basis of race, of gender, etc. But also emotion recognition, the idea that AI can predict our emotion. I'm happy to talk about these prohibitions with anyone in the future, but this is what I would like to see in terms of prohibitions. The second recommendation is that we think that this current proposal needs to do more so that the people that are, the institutions and the people that are deploying AI, using AI, need to have more obligations on them, not just the companies that are developing them, but the systems that are putting AI into practice need to be regulated better than they currently are. And that includes, as Griff has already mentioned, the need for a mandatory human rights impact assessment for all AI systems. But also we think that particularly if an entity like the police or a migration control authority or a social welfare authority is proposing to or thinking about using an AI system, that they should also have to consult with institutions, civil society, and social partners like the organizations that we see on the panel today to say, actually, should this happen? We also think that the results of all of this analysis should be published somewhere online so that when we're doing investigations, we're able to see if the analysis that has been done about the impact on people has been done properly, and so that we can test it. The third recommendation I have is that we need effective remedies. People need somewhere to go if they've been harmed by an AI system. They need somewhere that they can flag it to a public authority, and they need a legal route by which they can contest it. And that currently doesn't appear in the AI Act. And then the last one, I'll be very brief, is that for those looking a little bit closer at the EU's AI regulation, that there are a number of criminal justice loopholes that we think risk enabling even more discriminatory surveillance. So there are some exceptions for AI that is used in the context of international law enforcement, but also migration control, that we think sort of reiterate this notion that actually AI in policing has more benefits than it has risks. As we all agree, that is, we think that's a fundamentally wrong assumption to make. And actually the fact that the consequences that could stem from the use of AI in policing, as we've all talked about, actually probably warrant the need for stronger scrutiny, not less scrutiny on when the police and law enforcement want to use AI. And therefore, to meet sort of democratic principles, we actually need to be a lot stricter on the use of AI in policing, not less strict. And that's it for my recommendation. But as I said, like, I'm really happy to join this event, and I'm really hopeful with the increased political awareness and political resistance to the link between AI in policing. I would just say that things that people can do policy-wise, EDRI are doing a lot of work to try and work with other communities, other human rights organizations to coordinate a more collective resistance to some of these harmful uses of AI through something called the Digital Dignity Coalition, but also through our policy work. So if you're an organization that would like to work more on this, I would really recommend that you get in touch with us. But also for individuals, we are running something called the Reclaim Your Face campaign, which is a public campaign calling to ban facial recognition and other biometric mass surveillance practices that are used in the public sphere. Many of the harmful use cases that we've talked about today are very much linked also to biometric surveillance practices like facial recognition. And we think that much of this resistance goes hand in hand. Just as we are concerned about individual risk assessments, we should also be concerned about facial recognition in the public sphere. So if you'd like to support us in our call for a ban, you could go online right now and sign our petition, which is a European Citizens Initiative, and their website is called reclaimyourface.org. And with that, I'll stop, and I hope I didn't go too much over time. Thank you.
Thank you very much, Sarah, and thank you for the outlining the recommendations and your reflections on the broader structure in which these systems are are coming in particular the ever extension of criminalization, as we've seen during the COVID-19 health crisis, with increasing powers being given to police, increasing offenses being created, and the power of private companies as well, absolutely key. So thank you very much, Sarah. And we've been looking at the very many comments and questions in the chat, the Q&A. So thank you very much. And thank you in particular for all the kind words of support that came through to Diana, and support for her struggle that everyone is very much on side with. So thank you for all those comments. And since we are short on time, I just wanted to pick one question, if that's all right, that I will turn first to MEP Vitanov, and then ask Diana if you want to conclude by sharing a few thoughts and reflections based on the conversation and the various discussions today. So the question is, first on, I'm reading it out. There have been stories in the last few days that many national interior ministers want to split law enforcement uses of AI out of the rest of the AI Act. And the question is really open to the panel. And if I can put the question first to MEP Vitanov, if you have a response to that.
Thank you, Laurie. I also read the question, but to be absolutely honest with you, I haven't heard any intervention. I can tell about the Bulgarian interior minister, but I was thinking I haven't heard anything about that. But my explanation could be simple. I think that because of your job, because of all those people that are raising concerns about the potential risks and dangers of using AI in the law enforcement, that might bring this awareness to the political figures. At least this is my simple explanation, since I have no further information. Thank you.
Thank you. Sarah, do you want to react to that question?
So the question was from my colleague Ella Jakubowska.
Okay.
we have the same information, and so I don't have anything to add, but I would like to emphasize how potentially problematic that split could be. Already, as I've said, like, we're seeing this notion, like these repeated assumptions that essentially that surveillance is safety, right? And so the notion that police need to use incredibly invasive, rights violating biometric surveillance practices in order to do things like, and the common arguments are, find terrorists or protect victims of crime. However, we've really seen that any attempts to do that do not meet legal standards of necessity and proportionality, but also are incredibly disproportionate in general, in terms of the fact that we do not need complete public surveillance, a Big Brother style surveillance on everybody in order to prevent crime. Well, I think what we, and now this is my personal opinion, what we need is a fundamental redistribution of wealth. We need to redirect resources to social and economic causes. This is what is going to make us safer, not surveillance.
Thank you, Sarah, and I think that will resonate with Diana and her experience as well. Griff, did you want to react to that question before?
Yeah, thanks, Laura. I mean, that's an interesting proposition. I mean, it could be helpful to kind of focus in on the law enforcement and criminal justice uses of AI and look at that separately, because it means you can focus attention on the harmful issues, make specific laws, regulations around those harmful uses, maybe even specific prohibitions around particularly harmful uses. But in the context of when this has been done, when attention has been split in that way onto different areas, for example, with the General Data Protection Regulation and the Law Enforcement Directive, it meant that actually when it came to data protection, the use of data by law enforcement under the Law Enforcement Directive was much more watered down. The protections were much weaker. Even though it was a much more serious area that deserved much more stronger protections, it actually turned out to be the opposite. but it remains to be seen. I guess we'll have to address that if that's what happens.
Thank you. Martin, did you want to react before? Because we're now running out of time. Well, we've over time. So I'm going to go soon, unfortunately.
No, yeah, but I just I agree with Griff. You have a problem if you risk to have to separate act with one for law enforcement authorities with lower safeguards, and this is a real issue because already I think in the AI Act, well, we have. We need more safeguards, of course. And for example, regarding the prohibitions of Article 5, which are not prohibitions actually, when you are reading the exceptions. And so I think, yeah, this is very dangerous. It depends if they want to have a clear different act with clear and more stronger safeguards actually for the law enforcement authorities and the use of the AI by police forces. In that situation, and also in the criminal justice systems, in that situation, it will be useful if we have real safeguards, but otherwise, I think, you know, it will be a problem.
Thank you, Martin. Diana, do you want to share with us a few final thoughts and reflections before I close? Thank you.
Yeah, first I didn't understand from why the hell Griff contacted me, but now I understand because everything comes together. Because now I see all the questions I have been answered, and thank you. I think the mothers will be very happy with this, and I hope they meet you. There are more raising voices because a few mothers were talking about this, and I'm thinking, why are you talking about this? They said they're profiling us. And I didn't believe them. And in the beginning, and after my own research, I said, they were right. And I hope they will speak up too. And I will keep Petar, did I say your name right? Yeah, I will see you.
Peter or Peter, whatever.
Yeah, Petar. Yeah. I will put you to that invitation.
Yeah, it sounds like you two should be in contact for sure.
Yeah. Yes. No, but thank you, everybody. And I hope you all keep fighting because for you, it's behind the desk, but for us, it's real life. It's real life. Families get destroyed and children are taken away from mothers. And it's all about a system. So I hope you all remember us when you think you're tired, or it's not going to work, or you just want to give up. Remember us. It's for us you're fighting. So don't give up. We need you. Thank you.
Thank you, Diana. That couldn't have been more inspiring. Thank you so much. Thank you to all our brilliant speakers and for the great audience participation. Thank you for Griff for his terrific work, and to the whole Fair Trials team who've helped with the report and today's event. And please, as Sarah said, as everyone has said, let's continue to this discussion. The more voices are heard, the better informed the EU legislative process will be, and hopefully we'll be able to put an end to these practices. So let's stick together, and I look forward to staying in touch with everyone.